Welcome back. We are still covering the Rosenbaum case out of Georgia. And again, the defense pathologist is on the stand testifying during the cross-examination. We have not gotten to the redirect, which we're anticipating as yet. So let's jump right into court and listen to what he has to say. So the prosecution is taking a break after cross-examining this witness. It appears, Lakai, that the prosecution did a fairly good job of pulling apart his credibility. I'm hearing things of the nature of he might have retired under suspicious reasons. He may have falsified some certain documents. And there's some news articles that draw into question his credibility on previous cases. I mean, my first question, if I had the defense attorney here, is you couldn't find a better witness to testify for you that's a little bit cleaner than this? I mean, what's the jury to make of this?
Well, you know, Ryan, you never know the background, but they may have had difficulty finding an expert that was going to testify in accordance with what their theory of the story is. So this may have been the only person that they found that was testify consistently with the defendant's version of what occurred on that day. Unfortunately for the defense, they have certainly poked holes in this expert's credibility. They talked about the fact that first he couldn't determine whether or not it was an accident as to the cause of death or if it was undetermined. He's gone both ways. There's question about whether or not he committed a felony potentially and had to retire or terminate his position early. So they have certainly done a good job with poking holes within this expert's testimony. But the question is whether or not the defense could find anybody else to testify consistently with what their version of what occurred on that day is.
Yeah, and in previous testimony, we heard that the prosecution was able to proffer a theory that it wasn't just this chicken bone that could have caused the death of Layla Daniels, but it also could have been, or more likely than not, a seizure due to the ongoing trauma that they're alleging occurred to her. I mean, if this becomes a battle of the pathologists, a battle of the doctors, it seems that one side is a little stronger than the other.
I would agree with you at this point. You know, we don't know what's going to happen on the rehabilitation. And so, of course, the defense attorney will have an opportunity to come about and hopefully rehabilitate this witness and this expert. But the prosecution has done a good job with poking holes in their case thus far.
Now, again, what Lakai is talking about in terms of rehabilitating the witness, and you can kind of see it here. We're going to get back to her in a second. The defense has the opportunity to come back and re-examine the witness. And the trick to this is you definitely want to combat the negative that the prosecution just came up with. But you also want to make it so narrow that upon redirect, you have the ability to get up and say, hey, this is beyond the scope. You may or may not hear that phrase being used, but beyond the scope, meaning that, hey, I only re-examined them on this small aspect. I don't want them then to try to solidify other arguments that I didn't touch. But we're going to come back to the Rosenbaum case and more after this break. So there you have, as we were saying earlier, the defense attorney re-examining their own witness. Now, we heard some information about the development of science and how this might apply in other cases, and in this case, Lakai, you brought up a great point during the break as to how this should actually be interpreted for the jury. What was it that you were saying?
Well, I believe that the defense attorney is doing a great job talking about the fact that science is going to evolve, and you want science to evolve because there are certain things that are developed as a result of science evolving. However, when you are in front of a jury, the jury wants to see the black and white. They want to understand how science relates to the facts of this case. And so I think that's where the defense attorney is missing it. There are rare occurrences that exist, but they're not necessarily talking about those rare occurrences and whether or not this is one of those rare occurrences, and science applies to support the theory of the defendant's case.
I mean, the question becomes, and I fully agree with what you were saying, and it kind of touches on what we said earlier, is the defense attorney kind of floating around or glossing on that subject that you brought up, that trying to get the hard science to fit the facts here? Are they doing it because either they don't have the science to fully support them, or are they doing it because they're not really drilling in to the subject matter? And that leaves a question and maybe a door, ajar, fully open, off the hinges, we don't know, that might allow the prosecution to walk in and make this case. Is there anything that you can see that the prosecution might be able to either get back up on it and re-cross-examine, or do you think this is where the prosecutor should let dogs lay and kind of, hey, I'll take care of this on summation?
I think that the prosecution has already done a good job laying the foundation to doubt the credibility of this particular expert. I think that the prosecution should certainly let dogs lay, let the testimony stand for itself. I don't necessarily think that the defense attorney is doing a great job on the redirect. And so I think that they should allow that to sort of stay in the jury's mind moving forward and not necessarily ask this expert any additional questions to cause any more confusion.
And let's see if the prosecution actually does that after this break. Welcome back. Now, before we are done for the day, I definitely want to thank Lakai Vinson for joining us today with the expert analysis. Make sure you stay with us afterwards to continue with the Daily Debrief with Aaron Keller. Now, Lakai, as we're watching this and listening to this testimony, I know the witness is still up on the stand. How do you think that this testimony fits into the trial as a whole?
Well, I think back to our first point, Brian, is that the prosecution has done a good job with poking holes in this expert's case. They have brought into question his credibility. They brought into question whether or not he's even able to determine what the cause of death is. And he said on the stand that it's been both accidental and it's been undetermined. So the question is whether or not this expert's theory of the case supports the defendant's story as to how this incident occurred. And unfortunately, I don't think it's enough. I just think that this expert witness did not do enough to support the defendant's statement about how this occurred. So unfortunately, I think the prosecution did the best with poking the holes in the case. I think that the defense expert's credibility just didn't come through, probably didn't connect with the jury, although he tried, and I just don't think it's enough. And so I think from what I've heard thus far, with the scientific knowledge being the foundation of this case, it's just not enough. And at this point, I think the defendants are likely to be found guilty.
Yeah, and again, it's, I get it. We've talked about this during the break. You and I both come from defense backgrounds, started as defense, still in defense now. You always want to try to see at least some information presented to give the jury something to chew on, something to think about. But this seems to be a witness that could have carried the day, but doesn't seem to really have done that. Do you think that there's another witness that can be presented to try to help that out, or is this kind of it for them?
Well, the only other witness that would be capable of doing that is the defendants themselves. And so that opens up a completely different can of worms once you put the defendants on the case. What you want to do is put this expert on the stand and get this expert to tell the defendant's story without having to put the defendants on the stand. But because this expert was not capable of doing that and his credibility was called into question, then I think it creates a losing situation for the defendant. So I don't think there's anybody else besides the defendant themselves. And I think it's very unlikely, given all of the evidence about the previous lacerations and abrasions, that they are going to put the defendants on the stand.
And as you can see in the background, everyone is standing up. That is typically a sign of the jury walking out. So I think it's a perfect time for us to be backing out of this case. If you recall, we still have the other cases that we are following, that being the Amato case and the Nachman case. If you want to follow with those, you can always go to the Law and Crime Trial Network online. We also have Aaron Keller joining us for the Daily Debrief. Lakai, I want to thank you again, and hopefully we'll see you back very soon. Everyone else have a good day. Have a good one here from Brian Buckmire at the Law and Crime Network.